Good morning, everyone, and welcome to the first event for the ICTR 20th anniversary commemoration celebration. We are starting off this week's events with the 7th Colloquium of the International Prosecutors, and we welcome you all here to Arusha. This morning, we'll start off with an opening session, which is a public session. We'll then move into a series of closed session meetings for our international prosecutors and national prosecutors and other invited guests of Prosecutor Jallow. A few logistics. If anyone has any questions about this week's events, or the colloquium in particular, we have our two organizers, Teresa Berrigan and Abu Bakar Tambadou, over there on the side. And they'll be happy to assist you with any logistical issues that might arise. Also on the tables before you are passwords for Wi-Fi access. If anyone needs assistance with that, please see us. We'll be happy to assist you. We are on a very tight schedule because we have a very full program of events. And so we'll be keeping time of each event and trying to stay as much on schedule as possible. We're a little bit behind right now. So I'd like to turn it over to Prosecutor Jallow, who will host the opening session and introduce our distinguished panel. Thank you.
Good morning, ladies and gentlemen. Honorable Chief Justice of the Republic of Tanzania, honorable judges, representative of the Mayor of Arusha, honorable registrars, respectively of the ICTR and of the Mechanism for International Criminal Tribunals, my colleagues, prosecutors, national and international, and I'd like to recognize the presence of the prosecutor of the ICC, Madam Fatou Bensouda, and the prosecutor of the residual mechanism for Sierra Leone, Brenda Hollis, and the representatives of the prosecutors of the ICTY, the Special Tribunal for Lebanon, the Cambodia Extraordinary Jurisdiction as well. Ladies and gentlemen, I'm delighted to welcome all of you to this 7th Colloquium of Prosecutors. The route to this particular colloquium has taken us through various places and brought us full circle back to Arusha, where we first held a colloquium of prosecutors some 10 years ago, exactly in November 2004, hosted by the Office of the Prosecutor of the ICTR. Since then, we have together journeyed through Freetown, Sierra Leone, as guests of the Special Court for Sierra Leone. We've been through in 2005, The Hague, the Netherlands, in October, guests of the ICTY, in Phnom Penh as guests of the Cambodia Extraordinary Jurisdiction, again in Kigali, in Arusha in 2008, which was, I believe, the first time that we included the prosecutors from the national jurisdictions in our meetings. Then in Kigali in 2009, in Freetown, again in 2011. And at each stage, this colloquium provided prosecutors with a forum for consultations and for discussions on the current challenges of international criminal justice. This year, the colloquium is significant in several respects. It is significant in that it is being hosted by the ICTR on the 20th anniversary of the Rwandan genocide of 1994, in respect of which, as you are all aware, of the holding of the appeals chamber in the Karamera trial, the prosecutor versus Karamera and others, that there is no reasonable basis for anyone to dispute that during 1994, there was a campaign of mass killing intended to destroy in whole or in part, at least in very large part, Rwanda's Tutsi population, and that campaign was to a terrible degree successful. A few days hence, on the 8th November, we shall be marking the 20th anniversary of the establishment of the ICTR by the UN Security Council. Earlier on, we commemorated the 20th anniversary of the genocide in April here in solidarity with the people of Rwanda and in solidarity with the rest of the international community. This year, for the second time, the international prosecutors are also meeting with the national prosecutors, together with representatives also of the regional courts, as well as academic institutions and non-governmental organizations, to discuss this critical issue of the challenges and prospects for local prosecution of international crimes. In short, how do we overcome the challenges to complementarity, and how do we make it work? Over the past 2 decades, the ICTR has been part of that global struggle for justice and accountability in a network of tribunals and of national courts that has seen the tremendous expansion of international jurisprudence, the development of techniques in the management of the difficult and challenging aspects of international justice, and above all, in holding to account hundreds of persons who in the past might have evaded any legal accountability for their actions. This network of ad hoc and hybrid tribunals has contributed significantly to making international criminal justice a necessary, viable, and an acceptable mechanism today for combating impunity, for promoting accountability for mass crimes, and also for the maintenance of peace and security. As it stands on the verge of closure in 2015, next year, the ICTR, having indicted 93 senior figures for genocide, crimes against humanity, and war crimes, has now arrested all but 9 of the indictees, the cases of 6 of whom have been referred to Rwanda, and 3 now fall under the jurisdiction of the Mechanism for International Criminal Tribunals. The first instance trials of those arrested, excluding some who died in detention, and the cases of indictments which were withdrawn. These cases have been concluded with 61 convictions for genocide and related crimes and 14 acquittals on trial or appeal. At the moment, only the appellate proceedings in the case of Prosecutor versus Nyiramashihuko and others, what we call the Butare case involving 6 accused, scheduled for hearing, remains on our books. And it is scheduled for hearing in March 2015. That's the only case which stands between the ICTR and closure. I would like to seize the opportunity to record our appreciation to all whose support of the tribunal has contributed significantly to the achievements of the court, to the government and people of Rwanda, to our hosts, the people and government of Tanzania, to the thousands of witnesses who have, despite numerous challenges, testified before this court to enable it to arrive at the truth, to the very many other countries which have collaborated with the tribunal in the tracking and arrest of fugitives, in the provision of evidence, in relocations of vulnerable persons, and in many other critical areas. And of course, to all our staff who have over the years worked so hard and so diligently to ensure the success of this enterprise. We also seize the opportunity to call on the other countries to live up to their legal obligations to ensure the arrest and the transfer to the appropriate jurisdiction of the 9 remaining fugitives. The choice of the theme of this colloquium, Local Prosecution of International Crimes, Challenges and Prospects, as well as the presence of national prosecutors from some 20 countries, are not fortuitous. Both have been dictated by the transition at which international criminal justice stands today, with the impending closure of the ad hoc tribunals and hybrids a few years hence. The process of international criminal justice must always remain an option for the international community, for it has, despite some of its limitations, the distinct advantage of ensuring accountability in cases where local justice is unable or is unwilling to act. We must therefore continue to give our full support, our full and unreserved support and commitment to the international courts, particularly to the ICC under the Rome Statute, which soon would be almost the only tribunal, international tribunal on the scene. We also need to recognize that much of the success of the past 2 decades in this area has been the product of an effective partnership between international and local justice mechanisms, and that the future lies in consolidating and enhancing that partnership. The transition from primacy to the principle of complementarity reflects the primary responsibility of the state for the investigation and prosecution of the international crimes in the context of a partnership with international mechanisms. The emphasis on the role of national jurisdictions in the prosecution of international crimes is the product of several factors, including, as I mentioned, the impending closure of some tribunals within the next few years, the experience of the tribunals in building up effective partnerships with local jurisdictions for the transfer of cases to national jurisdictions, the shift from primacy to complementarity under Rome Statute, the establishment of the international residual mechanisms, in fact, for international criminal tribunals, that makes the completion of the remaining work of the ad hocs a priority, the strengths and challenges of international criminal justice, as well as the distinct advantages and benefits that local justice can contribute to communities that are affected by conflict and mass atrocity. It is therefore necessary at this critical stage of transition that consideration is devoted to the policies and the practical measures that are required to give concrete reality to this primary obligation of states. That is a major challenge that international criminal justice faces today. The prospects of accountability for mass crimes will suffer if it continues to depend on limited international processes and unable or unwilling local jurisdictions. The expected outcome of this colloquium will thus be the identification of measures in the light of the lessons learned from inter alia the work of the tribunals, from the efforts of national jurisdictions to prosecute international crimes, and from the implementation of the ICC program of complementarity. The experience of the ICTR in the referral of cases to national jurisdictions in Africa and in Europe, in my view, provides some useful lessons for the empowerment of local jurisdictions, and we shall be discussing those in greater detail in the next session, that is panel 1. The colloquium provides us with a good opportunity not only to consider the theme in the abstract, but in practical ways which will enhance the global effort to ensure accountability through legal processes. Thus, we should consider the extent to which local jurisdictions are discharging their responsibility to prosecute international crimes, its impact on justice for victims, on accused persons, and on communities, the challenges, political, legal, financial, practical, etc., that local jurisdictions face in this endeavor, and how these challenges can be addressed. The key lessons that can be learned from the work of the tribunals, and any possible support that such tribunals can provide to local jurisdictions. What can the local jurisdictions themselves do, and the international community, what can the international community do to give concrete effect to this primary responsibility? These are some of the issues that I hope we shall be looking at in the course of the next 2 days. And I do look forward to a very, very fruitful discussions and a very useful outcome to the colloquium. I would like to thank you once more for your very encouraging response, for your presence at this colloquium today. Thank you so much for coming. Now I have the pleasure to invite Mr. Majola, Bongani Majola, the Registrar of the ICTR, to make some remarks. Bongani.
Thank you, Prosecutor Jallo, for giving me the opportunity to make a few remarks. I would like just to reiterate what you said when you welcomed the guests and you recognized some of our distinguished guests who are here with us, and I would not, in view of the fact that the time is gone, I would not go back and mention them, but I'd like just to incorporate your remarks into my remarks and say to all the distinguished guests and visitors who are here, I'd like to welcome them very warmly to Arusha. I feel very honored to join you today at the opening of the 7th Colloquium of the International Prosecutors, which gathers lawyers from various international tribunals and courts and national and regional prosecuting authorities and other stakeholders. I am quite pleased that at the sunset of the ICTR, I am able to attend this last colloquium because I actually was one of the people who attended the first one. The impressive attendance I see today is living proof that international cooperation in prosecuting serious violations of international humanitarian law is a living reality. The peculiarity of the international tribunals is that they are meant to belong to the entire international community, or at least to serve its interests. One of the aspects of this quest for universality is that diversity must characterize our work. Yet, we must recognize that the diversity of the legal backgrounds, although an asset, may sometimes appear to be a weakness, especially when considered in light of the existing differences among our various legal traditions. I think particularly of colleagues from civil law backgrounds who may have had in several respects to forego a large part of their prior experience and embark, for example, upon the venture of conducting examinations in chief and cross-examinations, filing books of authorities to sustain their contentions, and adhering to all other common law requirements which were unknown to them in their previous experiences. It is partly in recognition of this reality that gatherings such as this one we have today are critical to enable prosecutors and lawyers from different legal traditions to meet and exchange ideas and best practices and lessons learned to enhance their experiences and knowledge. I believe that these types of gatherings are most welcome in a sense that they enable prosecutors from international tribunals to share experiences and lessons learned among themselves and with their counterparts who operate at national levels. This is profoundly important, mindful of the reality that not all crimes or gross violations of human rights can be prosecuted at the regional or international level. It is therefore useful to promote knowledge and experience sharing between prosecutors from international tribunals and those who prosecute at the national levels. This will help the latter to understand and appreciate the standards that are imperative in the successful prosecution of international crimes at the national levels. Since the establishment of the International Criminal Court, there has been a steady push to prosecute violations of international humanitarian law at the national level. The experience gained at conducting these prosecutions at the international level strongly supports this push. Not only is prosecuting at the international level expensive, but it is beset with many challenges, some of which do not exist at the national level. The prosecution of these crimes at the national level should, however, not have to reinvent the wheel, but must benefit from the experiences and lessons learned at the international level. That is why this colloquium is so important. I very much hope that an idea similar to this international colloquium of prosecutors, which the ICTR prosecutor put on the table some 10 years or so ago, will continue this enriching tradition to further the cause of international justice and accountability. I believe that it is through such rich networks of experienced prosecutors, both from the international courts and tribunals and national prosecuting authorities, that we can enhance our capabilities to prosecute some of the most challenging crimes of our time. I wish to associate, finally, my voice to that of the prosecutor who has just spoken in thanking both the high-profile speakers and participants, especially our keynote speaker, the Honorable Chief Justice of the United Republic of Tanzania, who has graciously agreed to be the keynote speaker in this event. I wish to thank the colleagues from many countries who, despite pressing commitments, have accepted our invitation to be with us today. I wish also to take this opportunity to express our gratitude to those institutions and governments who have made the organization of this event possible through their financial and in-kind support. Thank you.
Thank you, Mr. Bongani Majola. It's my pleasure now to invite Madam Fatou Bensouda, prosecutor of the ICC, to make some remarks.
Honorable Chief Justice, honorable judges, international and national prosecutors, Your Excellencies, ladies and gentlemen, dear colleagues, I am delighted and most grateful for being invited to participate in this colloquium of prosecutors of international criminal tribunals and special courts, which by now has become a well-established tradition. I am particularly pleased that this year the colloquium is held here in Arusha, which is in many ways a second home for me. It is where I have made great friends, many of whom are present here today, and where I have fond memories from the time I served at the International Criminal Tribunal for Rwanda. I would like to commend my cherished colleague, friend, and brother, Prosecutor Jallo, and his team for making this event possible ahead of the formal celebrations marking the ICTR 20th anniversary. Certainly, this is an important and appropriate moment to reflect with some measure of content over the advancement of international criminal justice and the achievements of the various international criminal courts and tribunals over the past 2 decades. This is not to say, of course, that our work is anywhere near done, as conflicts that generate mass suffering continue unabated in a number of places in the world, affecting millions of people and hitting hardest at those most vulnerable in society, the women and children. The theme of our discussion for the next 2 days, local prosecution of international crimes, challenges and prospects, is therefore a very pertinent one, and certainly one that underpins the Rome Statute system. This system is built on the International Criminal Court's respect for the sovereignty of its states parties. Indeed, the Rome Statute, in its preamble, recalls the duty of every state to exercise its criminal jurisdiction over those responsible for international crimes, thereby giving states parties the primary responsibility for preventing and punishing atrocities. The Rome Statute was never intended to replace national courts, and the system it created will only succeed if there is genuine national action. The International Criminal Court, through the principle of complementarity, was engineered to incentivize accountability efforts at the national level. In this sense, as I previously stated publicly, the ICC should be seen as the extension of efforts here in Africa as well as in other continents to end impunity for mass crimes. The referrals to my office by the national authorities of the situations in Uganda, the Democratic Republic of Congo, in Mali, as well as most recently, and for the second time, by the Central African Republic, are testament to this symbiotic relationship between states parties and the court. This is further exemplified by the operational cooperation and assistance my office receives throughout its investigations from states parties and states not party to the Rome Statute alike. Without such cooperation, we could not have achieved some of the milestones, such as the conviction of Thomas Lubanga for the recruitment and use of children as child soldiers. But that said, and given its limited infrastructure and resources, the ICC will not be able to and was not actually designed to cope with an unlimited range of cases. The ICC is a court of last resort, but it does not operate in a vacuum, and it is certainly not a panacea. As one actor in the global judicial system, we will, wherever we can, within our core legal mandate, cooperate with and support all genuine efforts that are aimed at bringing to justice those alleged to be responsible for the commission of mass crimes. I will speak more about this in detail in the panel that is coming. It is our firm belief that efforts to strengthen the rule of law at the national level and reinforce complementarity activities should be enhanced. Prosecuting crimes should not only be seen as satisfying conceptions of retribution, but also as a means to prevent perpetration of crimes. Universality of the Rome Statute and implementation of statutory provisions into national legislation should remain key goals, as knowledge of the existence of enforceable law and its systematic implementation can deter potential violators or stop existing perpetrators from continuing their criminal behavior. In similar fashion, each case before the ICC can have an exponential impact reaching beyond the confines of the courtroom. We need other actors, the politicians, the mediators, international and regional public servants, civil society, members of the legal profession, and this is just to name but a few. We need them to appreciate this. These various actors' acute knowledge and awareness of its work and the work of the court can help to maximize its potential positive impact. There is already clear evidence that our cases have been used to change behavior and stimulated the demobilization of thousands of children, child soldiers in Nepal and in Sri Lanka. The Lubanga case, we understand, has also had a cooling effect on the recruitment and the use of child soldiers in the DRC. Additionally, our growing case law is shaping prosecutorial approaches in other countries. Your Excellencies, ladies and gentlemen, to be sure, while local prosecution is the preferred road of the Rome Statute, and while my office will provide all possible support within its legal mandate, I shall not hesitate to assume my responsibility if those alleged to be responsible for mass crimes, irrespective of status or affiliation, are not brought to face genuine and real justice. I will do so wherever the court's jurisdiction is established, in Africa or elsewhere. That is my mandated duty and my moral imperative. All justice may be local, but no justice is not an option. I thank you for your attention.
Thank you very much, Madam Bensouda, a dear friend and colleague and younger sister. Thank you. I now have the pleasure to call on another colleague and friend, Richard Muhumuza, Prosecutor General of Rwanda, who has been a very, very strong partner of the OTP of the ICTR. Richard.
Good morning, everyone. Muraho. Greetings from Kigali. Honorable Chief Justice, Republic of Tanzania, Honorable Prosecutor, Mechanism for International Tribunals, Honorable Prosecutor, International Criminal Court, Honorable Registrar ICTR, Honorable Prosecutor Generals, Attorney Generals, Directors of Public Prosecutions, Prosecutors, Excellencies, distinguished guests, ladies and gentlemen. It is my great pleasure to speak before such distinguished professionals with whom I share the greatest honor of representing victims of the most heinous crimes. It is particularly an honor for me to address members of an international fraternity that has and continues to prosecute the most high-level perpetrators of crimes so shocking to the human conscience that all of humankind is viewed as victims. Ladies and gentlemen, some of you are still engaged in this noble cause as prosecutors with international tribunals or as domestic prosecutors of international crimes, while some of you have gone on to different career paths. The work we do as prosecutors is tough. We are the front line of prosecuting acts that are savage, brutal, and barbaric, and involve hundreds of perpetrators, victims, and witnesses. The volumes of work involved in undertaking a proper investigation and prosecution of such cases are enormous and require dedication and commitment. This has, in some cases, resulted in diverse implications to prosecutors. For every case that ends in our favor, sometimes leaves us with at least one enemy, whether the convicted or the members of his family. But this does not diminish in any way the zeal with which we perform our duties. Your tireless work and efforts to bring to justice perpetrators of genocide, crimes against humanity, and war crimes are noble. Your efforts, while most unsung, provide justice for countless voiceless victims. Majority of you here were involved in the work of the Office of the Prosecutor at the ICTR. The very existence of the ICTR sends a powerful message to those who wish to commit international crimes. And the work you have done here, ladies and gentlemen, delivers a warning to those who do not value human life. So, on behalf of the countless victims and survivors of the 1994 genocide against the Tutsi, please accept the sincere gratitude of the people of Rwanda. As the work of the ICTR comes to an end, let us remember the dedication and sacrifice of the prosecutors and other tribunal officials who worked tirelessly to ensure justice for the victims. And let us never forget the victims for whom the work was undertaken. Let Rwanda's tragedy in 1994 be a lesson to the rest of the world. Let us be the ambassadors in our countries who advocate for justice wherever such crimes occur. Let me take this opportunity to extend my sincere gratitude to the ICTR prosecutor and the whole staff for the support the NPPA has enjoyed from your office. The capacity building efforts, the many trainings, the experiences shared, all have left us a solid institution ready to tackle any challenge that we may face. We at the National Public Prosecution Authority are currently working tirelessly to ensure that every suspected perpetrator of the genocide in Rwanda is brought before a court of law. We are currently focused on locating and extraditing suspected genocidaires wherever they currently reside. To succeed, we need the support of national prosecutors in whose countries extradition requests are sent to work with us. Genocide, wherever it occurs, is a crime against all of us. As we commemorate the 20th anniversary of the existence of the ICTR, let us commit to ensuring justice for the crimes that occurred in Rwanda in 1984 by cooperating in the extradition of suspected perpetrators. We are prepared to try all of them in Rwanda, however long it will take. Ladies and gentlemen, thank you very much for your kind attention.
Murakoze cyane to Robert, our colleague from Rwanda. It is now my pleasure to introduce our keynote speaker. It doesn't require much of an introduction. As Chief Justice of the Republic of Tanzania, he is more than eminently qualified to deliver the keynote address at a gathering such as this. But he has other qualities beyond being Chief Justice of Tanzania, which also make him so eminently qualified. Justice Chande has been one of the pioneers in international criminal justice. He has served as Chief of Prosecutions in East Timor several years. He has served at the ICTR as Chief of Prosecutions for several years in the early and very difficult days when they had to lay the foundations for some of the good work which has been going on in that tribunal. So he's a figure, Mrs. Chande is a figure who's very, very much familiar with and very much committed to the process of international criminal justice. And it's my pleasure now to invite him to deliver the keynote address for this conference. Honorable Chief Justice.
Good morning, ladies and gentlemen. Honorable judges, Honorable Prosecutor of ICTY and MICT, Hassan Jallo, Honorable Prosecutor of the ICC, Madam Fatou Bensouda, I recognize Brenda Hollis, Prosecutor of the Special Court for Sierra Leone, and those of other tribunals, Honorable Registrars, Honorable Prosecutor General of Rwanda and other Director of Public Prosecutions, distinguished jurists, ladies and gentlemen. I'm deeply honored by the invitation by Prosecutor Jallo to address this eminent gathering and to share with you a few reflections on this well-chosen theme for this symposium, Local Prosecution of an International Crime, Challenges and Prospects. I think we are all obvious to the cogent facts around us that reconfirm the imperative for conducting and enhancing effective national prosecutions as a most suitable mechanism for wider and greater accountability at the national level, the fight against impunity, the enforcement of the rule of law domestically, the promotion of national reconciliation, and I think most important, at least in our region, the awakening of democratic processes following armed conflicts or hostilities. I think while on first impression, the very theme and timing of this August gathering, which coincides with the United Nations Security Council expectation of the wrapping up of the completion strategy of the UN ad hoc tribunals, one may be grossly misled into perceiving this colloquium as a dying declaration. On the contrary, I think there is no doubt that on the demand side of accountability, the theme, I think, is a robust restatement of your institution's unrelenting efforts to strengthen and support national prosecutions of international crimes. International prosecutions cannot be divorced from national prosecutions, and the other way around is the same. They ought and they must validate each other. Distinguished participants, for many states, the investigation and prosecution of international crimes will be a first-time experience. When the ICTY began, following its establishment by UN Security Council 827 on 25th of May 1993, it too was encumbered with a number of institutional and functional hazards. The UN, which has an ingenious way of explaining circumstances, said at that time that it was doing pioneering work. Similarly, when ICTR began operations, following the adoption of UN Security Council Resolution 955 and 8th of November 1994, it too was initially beset with operational deficiencies of a substantial nature. Again, the UN, with its admirable way of describing situation, said there were toothing problems. So in fact, the first time in history that you have an international tribunal in Africa having an initial appearance was on 30th of May 1996 with the initial appearance of George Rutaganda. So I think the lessons to be drawn is that for many states, it ought to be anticipated that domestic prosecution of international crime will face challenges, and for many will face very serious challenges. However, I think they enjoy a net and clear-cut advantage, and this is the mileage and experiences gained by international prosecution. So I think if we are to take a position, then in the prosecution of atrocity crimes today, and to use the expression of one writer, navigating without a map is no longer or should no longer be an option. Distinguished participants, one of the visible challenges of domestic prosecution, I think at the threshold level, is the establishment of new or the strengthening of existing national mechanism and the legal framework for investigation and prosecution. First, not all 122 state parties to the Rome Statute have incorporated in their national laws or have even incorporated the offenses contained therein into their domestic penal codes. So this is something that needs to be done. Secondly, I think is a policy issue. The question is whether or not the most effective way to enhance is to prosecute the core international crime within existing state law enforcement system or arrangements, by their integration therein, or through a separate and distinct mechanism running throughout the whole chain of the criminal justice system. I think of recent, a critical debate has surfaced on this very issue in relation to the fight against corruption, money laundering, and organized crime, where many states have independent and specialized anti-corruption agencies expressly mandated to investigate and prosecute these crimes, but at the same time, the highest prosecutorial authority by express terms of many constitutions is the Director of Public Prosecution, over whom all criminal investigations and prosecutions lie. So the question here is whether effective domestic prosecutions are effectively conducted, I would say, by a spitting cobra with two heads or with only one. We should, of course, I think, commend those states that have already established a mechanism, be it Special War Crimes Division or special chambers and so on, and I notice most of them would be here at this colloquium. I think the third development that has gained momentum and which will affect domestic prosecution is the increasing pleas made upon states and their judiciaries including by international agencies of the World Bank and so on, to establish additional specialized courts within the higher judiciaries of nation states. Commercial courts being pushed by the World Bank, labor courts being pushed by ILO, land courts being pushed by Habitat, family courts being pushed, juvenile courts, and so on. So the mushrooming of specialized court also has an impact, in my view, on the overall institutional capacity of judicial system to effectively cope with domestic prosecutions of international crimes. I think fourthly, another challenge is in relation to military justice systems and martial court arrangements within the domestic system. Some are completely autonomous and separate from the criminal civilian justice system, and others where the civilian appellate courts have jurisdiction following trials by military courts and tribunals for penal code offenses committed by members of defense forces. So the question is domestic prosecutions of international crimes involving members of defense forces and other regular forces to be conducted exclusively through military justice systems or the civilian justice system, or both? How credible and effective would it be if they were solely conducted by the military justice system? And what does our experiences suggest? Dear participants, I think the most crucial denominator for the success of domestic prosecutions is the political will of states. Again, I think I must qualify and quantify this. I think without unyielding commitment by state authorities at the highest level, local prosecutions are rendered fragile, if not vulnerable. One, simply a question of adequate resources, particularly financial by states that hold the purse, I think is also pivotal, and I notice again that this issue is on your agenda. The political will and willingness of states to promote and facilitate the effective and transparent local prosecutions, I think, may come in many shapes and many shades and many colors. Brian Porto, in his book, May It Please the Court, Judicial Processes and Politics in America, pertinently proposes the following. Law results from politics, but it is not politics. There can be law without politics, but there is often politics without law. The law is neither non-political nor entirely political. Law and politics are distinct from one another, but they interact because lawsuits frequently present courts with legal questions that arise from political controversies. So invariably, domestic prosecutions of international crimes are born out of armed conflict or other situations of atrocity resulting from intense political controversies widely defined. So a challenge faced by local prosecution is the political will of states. I think one, to do away with the amnesty clauses or contained in peace agreements or as part of national reconciliation processes, or to avoid pressing for post-conflict accountability. I think there is another challenge in the political will of states is to accept or to permit domestic prosecutions of all persons accused or suspected of committing international crimes from all parties to an armed conflict or to a situation of mass atrocities, be it members of its defense forces or the opposing forces or the political divide from which it springs. So any perception of victor's justice deeply undermines any gains that may be clinched by domestic or international prosecutions. I think another challenge which is growing up is the whole question of the inviolability and immunity granted to heads of state and senior state officials. I know that the international tribunals has indicted a handful of sitting heads of state, but you know that in Africa, the 23rd Ordinary Summit of the Heads of State and Governments of the African Union amended the protocol on the Statute of the African Court of Justice and Human Rights by providing in Article 46 bis to the effect that no charges shall be commenced or continued before the court against any serving head of state of the African Union or anybody acting or entitled to act in such capacity or other senior officials based on their functions during their tenure of office. Most constitutions, a similar immunity for criminal prosecutions is contained in many constitutions. So there is a visible tension here between the provisions of the Rome Statutes, between the regional institutions and regional instruments, and so on. And I think this poses a critical challenge. But I think on the ground, for domestic prosecutions, the challenge arises is whether or not these local prosecutions will be informed by international law, by their own constitutions. The question again, how realistic would it be for incriminating evidence to be gathered, for witnesses to freely volunteer evidence or to be protected? Would, the question I ask, a local prosecutor, a DPP, be able to exercise his or her independence and be free from any interference when the very office is subject to policy direction from the highest state officials? In these circumstances, are the prospects for genuine prosecution inviting or not? Of course, there are no simple answers, no consensus to these complex and sensitive issues, but I think this is your purpose. You are here for them to debate and to guide us and to offer us your advice. Distinguished participants, another major challenge I see in the way of effective local prosecutions of international crime is the misreading by many states, law enforcement agencies, and many others of the complexity involved in the investigation and prosecution of such crimes locally. I think with ultimate respect, of the 122 states that had ratified the Rome Statute, I would suggest that a number would have significant challenges in mounting credible and effective domestic prosecutions meeting international and human rights standards. In the words of one author, the investigation and prosecutions of individuals, particularly senior military, political, and security officials, is a sensitive function even for countries with strong and stable domestic institutions. What about the ability of states emerging out of armed conflict of mass atrocities and whose law enforcement arrangements have been entirely shattered? The point is not states have not been vested with primary responsibility. I think prosecutor of the ICC emphasized on that. This is reflected in our policy of positive complementarity in Article 17 of the Rome Statute. And I think this should lead, in my view, to a real incentive, not a disincentive, for conducting effective domestic prosecution. I think this colloquium will be briefed, I hope fully, and we'll also discuss a number of country situations. So allow me to put on the table two examples, because I know that so that you do not have only positive examples, so I can suggest some negative examples. I think we all know The Economist. In an article published on 23rd of March last year, The Economist, which in Encyclopedia Britannica ranks as one of the world's leading preeminent journal of its kind, assessed the domestic prosecution of war crimes in one state in Asia the following way. The court process has become enmeshed within the country's internist politics. The war crime tribunals is poisoning the well from which the country will one day want to drink. The government interfered in the court's deliberations. Public discussions of the proceedings have been restricted. The number of witnesses were curtailed. One was even kidnapped on the steps of the court. In one case, the presiding judge resigned and the death sentence was handed down by 3 men who had not heard all the witnesses. In another, the defendant was represented by a lawyer who did not have nearly enough time to prepare a case. That also ended in a death sentence. Another example, the Sudan. The report of the High-Level Mission on Human Rights in Darfur, pursuant to Human Rights Decision 54101, was of the following view in relation to the Special Criminal Court on the events of Darfur. The effectiveness of this court has been limited at its best. This distinguished colloquium is best placed to discuss some of these critical challenges and to counsel how best to cure the gaps in local prosecution. In my view, not with a view to babysitting domestic systems, but to assist them in empowering them so that they can assume their primary responsibility in addressing accountability for these crimes within their national constituencies. I think I must not forget sexual and gender-based crimes. Already, for example, in the Great Lakes region, there is an initiative following the declaration of head of state and governments of 11 member countries of the Great Lakes region to adopt special domestic mechanism to investigate these crimes. There was a timeline in which ministries were directed to establish special courts and sessions to fast-track these cases. So domestic prosecutions of core crimes, I think, can also rely on these mechanisms in order to develop or to strengthen their prosecution. This is an area, I think, where there are many obsolete definitions of sexual-based crimes in national jurisdictions, and therefore more needs to be done if domestic prosecutions in this area needs to be effective. Another vital challenge, I think, in the whole scheme for effective local prosecutions is an independent, impartial, honest, and competent judiciary. And since I know most of them, one that is beholden to the law, one that can dispense justice without undue constraint, one in which there is public confidence, one that can fill the judicial role without improper political influence from external or internal forces. Institutional function and individual independence of the judiciary and of judges is an imperative for effective domestic prosecution. While constitutions and laws retain judicial independence in their provision, in reality, the judiciary in a number of states remains weak, is fatally under-resourced. It utterly needs strengthening if it is not to be overwhelmed by domestic prosecutions of international crimes. While many judges are versed and experienced in criminal law, very few, indeed very few, have mastered international humanitarian law. So there is a knowledge gap which needs to be narrowed, and judicial reform in many states, I think, remains possible for effective local prosecution. I think outstanding is also reform of criminal procedures so that they are no longer haunted by the ghost of the innocent man being convicted. I think I will be making a culpable omission if I do not refer to the independent bar, which again is indispensable for effective local prosecutions. No matter how atrocious the crime, they have a duty to zealously defend the interest of the accused, and I think their role has not often been well appreciated. I know that this again is part of your agenda, and I hope that you will have a great discussion on the effectiveness of the bar in enhancing domestic prosecution. To conclude, ladies and gentlemen, let me say these final remarks. As we are at the seat of ICTR and a branch of MICT, I think it will be incoherent if I remain indifferent to one issue concerning the prosecution strategy, and I expect will most likely be for you. In its initial years, ICTR sought the deferral of suspects and accused from state jurisdiction, the first of which for ICTR was a request from Belgium on 11th January 1966. The ICTY did the same to request a deferral from the Federal Republic of Germany in May 1996. The swing of the pendulum 10 years later, in 2005, inversely depicted in the prosecutor's request for referral of accused to Rwanda under Rule 11 bis of the Tribunal Rules, and the Trial and Appeal Chamber's eventual authorization of these referrals, despite early reservations, again demonstrate the inseparability and the linkages within the international and domestic prosecution. Last night, I had the advantage of reading a recently released book on complementarity, and it's titled Complementarity in the Line of Fire. And concerning deferrals, with the Prosecutor Jallo mentioned a few minutes ago from Uganda, concerning the situation in North Uganda, it says the following: the referral was the wedding ring in an arranged marriage of convenience between Uganda and the ICC. I think the prosecutor told us it's a symbiotic relationship, and I think let's hope that we will have a marriage certificate sometime in the future. So I think domestic and international prosecution should not be peddling in different directions, one upstream and another downstream. I think they ought to function in tandem if our fight for impunity and rule of law domestically, internationally, is to gain ground. Ladies and gentlemen, I thank you very much for your kind attention, and I wish you successful deliberations.
I'd like to thank the Honorable Chief Justice on your behalf, on my behalf, for his keynote address. I think the text will be available as one of the documents for the conference made available. Thank you very much, Chief Justice. I think you've provided a number of issues which should occupy us in the course of the next 2 days. That brings us to the end of the opening session, I think. We are having a tea break now. James, what is the arrangement now?
We have a little bit of work ahead before we move to tea break, because you'll see on the agenda we have actually a group photograph planned, and we invite you all to participate in that. The photograph will be taken down on the grass by the pool. So what you need to do from here is to exit, go to the main lobby, and head to the right out by the pool, and Mr. Tambadou will be directing you on that. And then as soon as the photograph is done, please head back up here, and right outside this conference room we'll have tea and light refreshments, and then we will resume promptly at 10:45. I'm sorry, 10:45. So please follow Mr. Tambadou. He'll direct you to the pool session where the photograph will be taken. As soon as that's done, please come back and enjoy a short break. And I remind you, when we resume at 10:45, we'll be moving into closed session. So please, only those who have been invited by the prosecutor to attend will have a little bit more space. So sorry for the people standing room only. All right, thank you very much.